Hey guys, here is a recent FDCPA Fair Debt Collection Practices Act case from the Southern District of Florida. Came out last week, April the 8th. And I want you to see it because it goes into a discussion of serving pleadings or lawsuit type papers on a consumer who has a lawyer. Does that violate the FDCPA? You'll also see the court discussing how things have to be pled in the lawsuit. In other words, what do you need to put in the complaint? And then we'll see the difference between a dismissal of certain parts of the lawsuit without prejudice and then dismissal with prejudice. So appreciate you guys watching this with me, and I hope you find it enjoyable. So this is against a big collection firm in Florida, Polak and Rosen. And what we have is a motion to dismiss the complaint. And so here are the basic facts that are in yellow. And the way I'll do this is when it's the court speaking, it'll be yellow. When it's the consumer, the plaintiff arguing, that'll be in purple, and the defendant will be in green. So hopefully that'll help kind of keep it straight. So here the court is just explaining what's going on. So this collection firm filed suit against the plaintiff in state court, and they filed a witness and exhibit list. So that's, as you're getting close to trial, typically a court will say you have to tell the other side who your witnesses are and what your exhibits are. In other words, what documents are you wanting to put into evidence? And so the defendants, these collection lawyers, instructed the state court filing system to email the filing to the plaintiff at his personal email, even though plaintiff was represented by a lawyer. And so the plaintiff got that, and the plaintiff's counsel had not consented to defendant's direct communication with plaintiff. They had not failed to respond to communications, and no court authorized the defendant, the debt collection lawyers, to speak directly to the plaintiff. So plaintiff files suit and says, in counts 1 and 2, you communicated with me when I was represented by a lawyer. And number 2, in those communications, you failed to disclose that you were a debt collector. And the defendant says, no, throw this thing out. There's nothing here that should survive. And so here the court tells us to survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. So that's the standard. And there have to be enough facts to plausibly allege the required elements. So when we say elements, we mean here's what you have to show, for example, in a Fair Debt Collection Practices Act case. And we'll see that in just a minute. So the defendant is using Rule 12, saying you don't meet the standard. And the plaintiff says, I do meet the standard. So here are the elements, and we've talked about this in other videos. Some courts break these into 4 elements, but this is certainly one way to do it. To prevail on FDCPA claim, you have 3 elements. Number 1, it's consumer debt. Number 2, the defendant's a debt collector. And number 3, the defendant violated the law. Now, sometimes courts will break out that first point and say you are a consumer and this is consumer debt. But you can also just do it like this judge has done it. So the standard is least sophisticated consumer. So it's not what would a consumer lawyer know if he or she got this pleading, but it's the least sophisticated consumer. And that won't really matter too much here, but the court's just pointing that out. Now, the parties do not argue about that this is consumer debt and that the defendant is a debt collector. So really, it's just this third factor that's at issue. Did the defendant engage in an act or an omission prohibited by the FDCPA? So here's counts 1 and 2. And the basic gist of this is, did you, the debt collector, communicate directly with the consumer, even though the consumer had a lawyer? And the defendant says, well, we didn't communicate. It was the state court filing system. That's what emailed the document to the plaintiff. So therefore, we did not communicate with the plaintiff. And they say, look, you consented to the communication because you added your name and your email to the online court system. So here's the response from the plaintiff in purple. Plaintiff argues the state court filing system requires the filer to designate the recipients. And so therefore, you, the collection lawyers, affirmatively chose to communicate with the plaintiff because you checked the box saying, yes, I want this witness exhibit list to go to the plaintiff. So now the court says, well, let's look at what the law is. And this is section 1692CA2. And it's without the prior consent of the consumer, it's then communicating with the consumer when the debt collector knows the consumer has a lawyer. Now, there's a few exceptions here. If the attorney fails to respond or the attorney consents to direct communication with the consumer. So then the FDCPA defines communication, because we need to know what that is, as conveying of information regarding a debt directly or indirectly to any person through any medium. And just a reminder, we have a whole series of videos where we go through each and every section of the FDCPA. And this is important, kind of the definition section, to figure out, well, what is a communication? So here's the defendant's argument. They said we did not communicate because the state court system is what did that. The plaintiff says, no, you chose for the plaintiff to get this. And the court says, taking the allegations in the complaint as true, defendants causing the state court filing system to send the witness exhibit list to the plaintiff would constitute an indirect communication. Remember up here, communication is communicating or conveying of information regarding a debt directly or indirectly. So here the court's saying this would be an indirect communication within the meaning of the FDCPA. So defendants, your first argument's no good. But here's the second argument. Defendants argue plaintiff consented to the communication by adding his name and email address. And here's where we get into the pleading standard. So the plaintiff brought this lawsuit, the FDCPA lawsuit, and the plaintiff does not allege in the complaint that he did not consent. Now, it's kind of, like a double negative, but saying you have to put in the complaint, I did not consent to get this. Now, I think that is something a lot of judges would not do, okay? But this judge is saying you have to put that in your lawsuit. So that's required to state a claim for violation. So again, 1692CA requiring the communication be without the prior consent of the consumer. So if we go back up here, we have it in bold, without the prior consent of the consumer. And so therefore, plaintiffs counts 1 and 2 failed to state a claim, and the motion to dismiss is granted. Now, we're going to see it's granted without prejudice, and the court is giving the plaintiff the chance to fix the pleading. So one little pointer here is, if you get a motion to dismiss, I always assume we should amend the complaint. And we take whatever the defendant has said. So for example, here, they go, well, you did not say that you did not consent. So we go, okay, whether I agree or disagree with that, I'll go, you know what, to avoid this battle, we'll just amend the complaint and we'll put that in there. Now, other lawyers don't do that. And, there can be different customs in different parts of the country. But some lawyers say, well, I'll see if the judge agrees or disagrees. And the judge agrees with them, surely the judge will give me a chance to fix this. But I've seen judges not give you a chance. And under the rules, it's Rule 15, you have the right to automatically amend your complaint when you get one of these motions to dismiss. So that's my tip for any lawyers that are watching this is go ahead and amend it when you get that motion dismissed. All right, well, here's count 3. What about the failure to disclose the status as a debt collector? So the defendant says, hey, this witness exhibit list falls within an exception where I do not have to tell you I'm a debt collector when I communicate. And the plaintiff says, no, that's not a formal pleading. And you should, saying to the court, you should construe this very narrowly. Well, let's look at this. So the FDCPA says, the failure to disclose in any subsequent communication, so we're not talking about the initial communication, but any communication after that, you have to disclose the communications from a debt collector unless it's a formal pleading. Now, if it's a formal pleading, you don't have to disclose that you are a debt collector in subsequent communications. So the 11th Circuit has not defined what constitutes a formal pleading for the purpose of this subsection, because remember, the statute says shall not apply to a formal pleading. So what is a formal pleading? Well, the 11th Circuit case, and that's the appellate court over Alabama, Georgia, Florida, said back in 2015, we need not determine what that is. So typically a court, if it does not have to make a decision on something, will sort of pass on it and say, well, we'll wait till we're required to make a decision on that. So here the judge says, I'm going to decide the witness and exhibit list falls under the formal pleading, and cites to a Southern District of Florida case that says motions, responses, notices of appearance, affidavits, blah, blah, blah. That means, or that fits within the definition of formal pleading. Now I'll say this. If you look, for example, at Alabama Rules of Civil Procedure, it defines what a pleading is, and it would not include this, okay? But this is what the Florida federal judge is saying. And then the court's also saying, look, obviously when you've been sued, you know that the creditor that sued you and the collection lawyers, everything they're doing is trying to collect the debt. So you can't be surprised about this. Now here's what the plaintiff's response is. Well, you should adopt a narrower definition based on Rule 7 of the Federal Rules of Civil Procedure. And that is something that, I mean, we can look it up, but my memory is Rule 7 sort of defines what a pleading is. But the court says, no, a broader interpretation is consistent with common sense. Plaintiff was well aware of defendant's status as a debt collector because defendant filed a complaint and they identified as debt collectors. And so the court says, because a witness and exhibit list constitutes a formal pleading within the exception of that 1692E11, so that's what we were looking at up here, is 1692E11 that says that it's a violation if you don't say you're a debt collector, but that doesn't apply if it's a formal pleading. So the court says, because I find this is a formal pleading, you failed to state a claim, therefore count 3 is granted. So ultimately the motion is granted. Counts 1 and 2, that would be you communicate directly with a consumer, are dismissed without prejudice. But count 3, that's what we were just looking at. Count 3 is, this argument that you didn't tell me you're a debt collector. Count 3 is with prejudice. So here the judge is being very nice, and so this is good for the plaintiff, is granted leave to file an amended complaint on or before 7 days. So this happened on April 8th. So presumably today, when I'm recording this video, the plaintiff is amending the complaint, but just on counts 1 and 2. So that's the case, and I hope you found that interesting. It's good to read these decisions if you are a consumer and you're going to be involved in litigation and you want to know what's going on. And definitely for lawyers that do this type of work, to see, well, how are judges handling this? Because I can tell you there's a lot of judges, at least that I practice in front of, that would not say you have the right to amend your complaint. They would say you should have amended that within, and it's 21 days from when you get the motion dismissed. And that's all under Rule 15, Rules of Civil Procedure, Rule 15A. So again, a reminder, figure out what you have to plead in your lawsuit to be successful, whether it's a fair debt case, a fair credit case, a trucking case, personal injury case, business case, employment, whatever type of case it is. Figure out those elements that you have to prove to be successful, and then make sure you plead those in your lawsuit. Okay, thanks for watching this video, and I'll catch you guys soon. Bye-bye.